So today what we're going to look at is types of law. And we've talked about types of law in the past, like we've talked about common law, we talked about civil law, criminal law, but there are other laws. We've even talked about administrative law. So we're going to kind of review back to the stuff that we looked at the beginning of the course and what we just recently covered. But when you look at law, you have to know who has the jurisdiction, the power to enforce, and you have to look at who has the power to rule, to judge on the matter. So the first thing we're going to look at is common law. And this is a review from back at the beginning of the course. Common law is law that is established by following earlier judicial or court decisions. So it's like common practice. What is commonly done in cases like this? Common law is based on English or British tradition. So the United States' common law is very similar to England's common law. We kind of copy it. When a lawyer is determining whether they're going to take a case or not, they always look at prior decisions in cases that are similar, and that lets them know whether they're going to win a case or not. It lets them know the odds. When lawyers are looking up your case and they're comparing it to other cases, they're trying to figure out in a civil lawsuit what was the winnings, the penalty amount in a case that's similar to this one. When lawyers do that, they're going to determine whether they're going to take your case for free with a percentage of the earnings or the potential earnings from that penalty, or whether they're going to make you pay up front. And that kind of lets you know about your lawsuit and whether you're going to win or not. Because lawyers, remember, they work on winning cases. You're only going to stay a lawyer if you're winning. So they look at the potential on that. So common law really does establish like a lot of laws. It establishes what has been prior done. You trip, you fall on a sidewalk in front of someone's house. Well, people have sued over that, and they've sued the homeowner because technically it's your responsibility to ensure that that sidewalk is in good order. Like if there's a huge crack, if there's a hole in it, as a homeowner, you are supposed to notify the city that, hey, there's this issue with the sidewalk in front of my home. Because if you haven't been taking care of it, you haven't been maintaining it, you put your trash can on it and someone trips, they could potentially sue you because it's happened in the past and the person's won. So it's like a law now. If there's a sidewalk in front of your home, you are required by law to make sure it is maintained and taken care of. The next kind of law is that criminal law, and we just talked about this. But laws dealing with crimes and their punishments. In order for somebody to be prosecuted under criminal law, they've had to break a government law. They did a crime. They committed a crime. This can be felonies, very serious offenses. It could be misdemeanors, less serious offenses. So felonies, good examples would always be like murder, kidnapping. Those would be felonies. You're talking serious prison time for a felony. A misdemeanor is like speeding. So speeding is technically a misdemeanor. When someone is speeding, they get a ticket from a police officer. Police officer gives it to them, or a sheriff, or highway patrol. One of those law enforcers is going to give that ticket to you, and you're going to pay it, but you can also, of course, always argue your case because you're being accused of a crime. You have a right to argue your case in a court. The thing that you should remember about criminal law is a hat very small. So an arrest has to happen. They get booked, they're brought in, mugshot, all that. Then the hearing, they're going to be brought in to a courtroom and they're going to hear the charges pending against them. Sometimes in place of a hearing, a grand jury is used. Grand juries are determining if there is enough evidence to go forward with a trial against this person. But that next step has to occur. They have to have a hearing or they have to have a grand jury. The next thing after that has occurred is the arraignment. The arraignment is going to be in court again. You're going to enter your plea, and you can enter a plea of guilty, not guilty, or no contest. Guilty most likely means a person has taken a plea bargain, and if they have taken a plea bargain here at the arraignment, and that's the only place it can occur, then they're going to skip trial, they go directly to the verdict and sentence, because you're admitting you're guilty. If the person says at the arraignment they're not guilty, they're going to then go to trial, okay, because they're going to fight the charges against them. And that's okay, like that's your constitutional right. After the arraignment has occurred, the trial is going to occur. So if the person said, no, I'm not guilty at the arraignment, they're going to go forward with a trial. A trial is a presentation of evidence. So the government, led by the prosecutor, is going to go against you or whoever, the defendant, the person who's being accused of the crime. At a trial, they present evidence. They can do it before a judge and a jury. After both sides, the prosecution and the defense, have rested their case, they said, we've argued as much as we can argue, we've proven, we've got evidence, we got facts, whatever. They're done. They're going to then go to the verdict. It's either going to be guilty, not guilty, or you could have a hung jury. In a criminal case, remember, all jurors have to say that this person is guilty beyond reasonable doubt, or they're not guilty. If they cannot come to an agreement, 100%, we're then going to have a hung jury, and a mistrial will be declared. The government can come after people again for the same crime if a mistrial is declared, because you weren't found innocent, you weren't found guilty, so they can come back after you. If the person is found guilty at the verdict stage, they're then going to go to the sentencing stage. If they're not guilty, they're free to go. At the sentencing stage, the person is going to have the punishment dealt. And remember, punishments have to fit the crime. No cruel or unusual punishment, no excessive fines or bail. So all that's, and it would just be fines at that part, okay? The next law that we're going to look at is civil or tort law. So laws that are dealing with wrongful acts and injured parties can sue. And a lot of times civil is common law. So they get in there together, okay? When you're talking about wrongful acts or injured parties, if it wasn't for this other person, you would be okay. Like if it wasn't for this other person, you mentally, psychologically, physically would be okay. So this is dealing with harms, with wrongs, and it's lawsuits. People do sue over a lot, and it is part of the reason why the legal system, our courts are kind of bogged down. They have a lot of cases that they're dealing with. But in a civil case or tort case, the first thing that's got to happen is the wrong. The person has got to feel that if it wasn't for this other person, they would be okay. Car accidents can be this way. Now, car accidents can also be criminal. And this is something you have to understand about civil and criminal. You can actually get charged with a crime, and the person can also sue you because of what has happened. And probably the most famous case where that stuff has occurred is the O.J. Simpson case. So O.J. Simpson was found not guilty. He was acquitted of murder charges, but yet he was found at fault in a civil lawsuit. So the family felt that he had wronged them. They filed a lawsuit. So the person who files the wrong is the plaintiff, and they're filing that wrong as an official complaint. And the complaint is going to say what is going on, what happened, and it could state how much damages they are seeking, how much money they're seeking, because lawsuits are about money. Now, whenever you are suing, you have to prove the dollar amount. You can't say, my injuries and my mental well-being is worth $10 billion. You got to prove that it really was that amount. So you got to have receipts. You got to have medical claims. You got to have stuff to get that kind, okay? Now, after the complaint has been filed at the courthouse, A summons is going to be sent, and a summons is an official statement that the person is getting sued, or the group, whatever. Now that the summons has gone to the defendant, the person who is being sued, they will respond. And at this point, they can try and settle it out of court. They can try and talk to the plaintiff and convince them that, no, we don't need to do this. But if the plaintiff doesn't agree, then they're going to go forward with the lawsuit. At this point, at any point in a lawsuit, the person who files the lawsuit can always drop it. They can always dismiss it. So civil, again, is always a little bit different than criminal on that. But once the summons has been sent and the lawsuit is on, both parties are going to continue the fight. You got the discovery phase, and that's where you're collecting evidence. And you need to collect evidence so that you can go ahead and defend yourself or get this person at fault for whatever you're saying that they did. After the next step is the trial. So in the trial phase, you're presenting evidence. Both sides are presenting evidence again. Once the trial has concluded, we're going to have the verdict. The only type of verdict you're going to have in civil is at fault or not at fault. And because they find someone at fault, it's going to be a penalty. It's going to be a dollar amount. And the dollar amount has to be something that is measurable for the person's wrong. It cannot be excessive. And if it is, remember, people can always appeal. So people do appeal decisions that have been made, particularly when the dollar amount has been really high. Right, the next law is constitutional law. Constitutional law deals with the interpretation of the United States Constitution. Whenever you're dealing with the U.S. Constitution, the only people who can interpret it would be the United States Supreme Court. So if someone has a complaint that their state has violated, infringed on their constitutional rights, and they sue the state, the United States Constitution, that case would be heard at the Supreme Court. The Supreme Court, made up of our 9 justices, have exclusive jurisdiction. They're the only ones that can hear it. So I always give the good example of Miranda versus Arizona. So remember the case of Ernesto Miranda. He gets arrested for rape and kidnapping, and he admits it. He signs away his rights. He was never told by the police officers that he had the right to remain silent because they did not inform him of that Fifth Amendment self-incrimination right. Because they didn't inform him, he signs away all of his rights, he's easily convicted, and he appeals his case up to the Supreme Court. He feels that it's a violation. Supreme Court agreed with him. They look at the Constitution, that Fifth Amendment, your right to no self-incrimination, as the government is supposed to let you know about that. So because they didn't, the case gets thrown out, but that was a constitutional law issue. The next law is administrative law, and this is done by our executive agencies of the United States government. So this is laws that they can create, they make them, they enforce them, and they rule on them, they judge on them. So the law the government uses to administer agencies of our government, any executive agencies like the Food and Drug Administration or the FDA. Any pharmaceutical drugs have to go through animal testing before they go to the human phase. That is a law. You are not allowed to test on humans. So remember, and that's part of that no cruel or unusual punishment. So you can't do that with prisoners. But in order for it to go to the human trial phase, it has to do a lot of checkoffs, and then the FDA will clear it for human trial.